Donald Trump's $10 billion lawsuit that he filed against his own government, against his own IRS, just blew up in his face, and interviews that he gave were some of the evidence that backfired on him. So, what went down moments ago? A federal judge in the Southern District of Florida just issued an order questioning whether there is truly a case and controversy between Donald Trump and his own federal government. For there to be jurisdiction, there must actively be a conflict between two parties. You can't just have two friends show up in court with a collusive deal and ask a federal judge to put a stamp of approval on an arrangement that those friends are working out between themselves. There has to be a real case and controversy, a real conflict. So this federal judge in the Southern District of Florida said, "Your $10 billion lawsuit, Donald, it looks very collusive. It looks like you are trying to use this federal court to bless or put a stamp of approval on a $10 billion payment to you from the IRS or from the Treasury Department. I am not going to do that." So instead of just allowing this charade to continue, the federal judge issued an order to show cause, meaning either Trump himself or Treasury Secretary Scott Bessent or someone from his administration must show up in court and explain why this is a real case and not a fraud on the court. I'm going to read for you in just a moment what this federal judge ruled. She is not letting Donald Trump get away with settling this case with himself. Now, one thing I think this court may do is the court may simply say, "I'm going to stay or pause this entire case until Donald Trump's term is over, at which point there could be genuine adversity between the parties rather than this collusive arrangement." The court is deeply concerned about being used to bless what appears to be a fraud. So let me show you what this court's order actually says. This is from the United States District Court for the Southern District of Florida. The federal judge is Judge Kathleen Williams. Here is the order. This matter is before the court on plaintiff's consent motion for a 90-day extension. In the motion, plaintiffs ask the court to grant an extension of 90 days on all proceedings in this matter. The only scheduled event at issue is the defendant's response to the complaint. For the reasons stated below, the court will sua sponte, meaning on the court's own initiative, stay the defendant's obligation to respond, and set a briefing schedule to address the question of the court's subject matter jurisdiction. In order for the court to have jurisdiction, there has to be an actual case and controversy, a real conflict, not collusion. What the court is saying here is this: Trump and the Trump Organization asked for an extension of time while they engage in settlement discussions with the defendant, the United States government, the Treasury Department, and the IRS. They're asking the court to grant a 90-day extension for those settlement discussions to take place. Meanwhile, the defendants, the Treasury Department, and the IRS are supposed to respond to the complaint. If there is a real controversy, they should file a motion to dismiss or answer the complaint. But instead, the court is saying, "I am not going to simply grant you this extension until I find out what is really going on here." The court goes on to say that on January 29, 2026, plaintiffs, President Donald J. Trump, Donald Trump Jr., Eric Trump, and the Trump Organization, filed a complaint against defendants, the IRS, and the United States Treasury Department. In the complaint, plaintiffs assert violations of 26 U.S.C. Section 61003, 26 U.S.C. Section 7431, and 5 U.S.C. Section 552A. These are data breach causes of action. What Trump is alleging is that in 2019 and 2020, the IRS hired a contractor, a man named Charles Littlejohn. Littlejohn took the job and leaked the tax returns of Donald Trump, as well as roughly 7,600 other wealthy individuals. This became a major expose in ProPublica and other outlets about how wealthy people avoid paying taxes. It was a significant IRS data breach, not just involving Trump's taxes, but involving the taxes of thousands of other high net worth individuals. The court's order continues. Before defendants could respond to the complaint, plaintiffs filed the instant motion requesting a global extension of time. The court then explains the law. Federal courts are courts of limited jurisdiction. They possess only the power authorized by the Constitution and by statute. This court has an independent obligation to police the constitutional and statutory limits of its jurisdiction. One such constitutional mandate is set forth in Article 3, the article of the Constitution that deals with the judicial branch, which limits federal courts to adjudicating cases or controversies. The existence of a case or controversy is a bedrock requirement of jurisdiction. The court cannot exercise judicial power without it. Accordingly, before the court can rule on the plaintiff's motion, it must confirm that it has jurisdiction. A key characteristic of the case and controversy requirement is the existence of adverseness, a dispute between parties who face each other in an adversarial proceeding. There must be an honest and actual antagonistic assertion of rights by one party against another, which is neither feigned nor collusive. Typically, adverseness is found in a situation where one party is asserting a right and the other party is resisting. If there is no adverseness, there is no case or controversy, and therefore no jurisdiction. In this case, the defendants, the Treasury Department, and the IRS have not yet filed any notice of appearance. They haven't even appeared in the case yet, and in a normal situation involving genuine adverseness, they would appear and file a motion to dismiss or answer the complaint. But instead, the parties have advised the court that they are engaging in discussions to resolve this matter through settlement. Moreover, although President Trump asserts that he is bringing this lawsuit in his personal capacity, he is a sitting president, and his named adversaries are entities whose decisions are subject to his direction. Indeed, Trump's own remarks about this matter acknowledge the unique dynamic of this litigation. Accordingly, it is unclear to this court whether the parties are sufficiently adverse to each other to satisfy Article 3's requirement. Here, the court uses Donald Trump's own words against him, even though Trump, the Treasury Department, and the IRS didn't formally file anything. The court notes that this is all part of the public record. Trump has issued executive orders stating that the Treasury Department and the IRS cannot act independently, that they need his approval for everything. That is unprecedented for agencies that are supposed to maintain a modicum of independence. Because this court is not going to be a rubber stamp for a fraudulent, collusive settlement agreement. That is not what courts do. I think that was a very significant finding by the court. And the court said, "Show up in court, Donald, and give us the information about why there is actual adversity. I am not going along with this charade." The court had hoped to evaluate this issue after the defendants responded to the complaint. But in light of the plaintiff's motion to extend deadlines to permit settlement discussions, the court said, "I am not okay with that. I will ask the parties to address the question of subject matter jurisdiction before addressing the relief requested in the motion. So, before we get to extensions and settlement discussions, I want to know that there is genuine adverseness and that this whole thing is not one big fraud. Accordingly, it is ordered and adjudged that by May 20th, 2026, the parties shall each file a memorandum of law addressing whether a case and controversy exists. In this matter, to establish the court's jurisdiction, a hearing is scheduled for May 27th, 2026. The parties should come prepared to discuss the issues identified above. Judge Kathleen Williams signed the order in chambers in Miami, Florida on April 24th. Now, you'll recall the interviews and statements by Donald Trump that the judge is referencing. Here was the interview Trump gave with NBC on February 4th, 2026, just a few days after he filed the lawsuit, in which he told the reporter that the lawsuit had essentially already been won. An admission, in other words, that there is no adverseness. He said, essentially, the lawsuit's been won. I guess I won a lot of money. I'm supposed to work out a settlement with myself. By saying he's settling with himself, there goes any claim of adversity, and there goes the $10 billion lawsuit. And then, when reporters in the Oval Office asked him why he was suing his own IRS, Trump turned on the reporter and said, "You're a loud person. You're obnoxious." He refused to answer the question. There were also Senate hearings on this matter. Democratic Senator Kim of New Jersey cross-examined Treasury Secretary Scott Bessent directly, asking, Trump himself said, "I am supposed to work out a settlement with myself. Do you think that is a conflict of interest?" Bessent deflected, saying it was a Justice Department issue. Senator Kim pressed, "No, he is suing your department." Bessent again said to contact the Justice Department. It should also be noted that a group of top former government tax officials filed an amicus brief before this federal judge, raising this very issue. The group included John Koskinen, the 48th Commissioner of the IRS, Catherine Keneally, former Assistant Attorney General for the DOJ Tax Division, Nina Olson, who served as the National Taxpayer Advocate from 2001 to 2019, and Gilbert Rothenberg, former Chief of the U.S. Department of Justice, Tax Division, along with nonpartisan organizations, Common Cause and the Project on Government Oversight. Here is what they urge the court to do, and it appears the court has taken that advice. They wrote, "The court should consider issuing an order for the parties to show cause why this court has jurisdiction over this case, to explain how they will address the fundamental conflict of interest problems with this case, to show why this case should not be stayed until after Donald Trump leaves office, and to show why the unjustified $10 billion damages figure should not be stricken from the pleadings." They also suggested the court appoint an independent amicus, an outside expert with expertise in tax law and separation of powers issues to provide objective legal arguments as the case develops. It appears the court has taken at least the first step. And just to remind you what this lawsuit is fundamentally about, Charles Littlejohn, a former IRS contractor, accessed and leaked Trump's tax returns, along with those of approximately 7,600 other high-net-worth individuals. The leaks fueled major investigative reporting on how the ultra-wealthy avoid paying taxes. The thing is, former presidents routinely released their tax returns voluntarily. That was standard practice. So the idea that Donald Trump was damaged to the tune of $10 billion because the public got to see his tax returns is, frankly, hard to take seriously. And apparently, so does this federal judge.